right, I've got 10 o'clock, so we can go ahead and reconvene the landowners meeting from back in June. We have proof of publications of both the original meeting and the new publication for the reconvene meeting are in your books. We have a quorum with the landowners meeting. It just takes one landowner, but we have several landowners present. As a reminder, this is a reconvene meeting. We're treating this meeting exactly as if the original meeting back in June never ended. We basically just took a break. We're not going to be introducing any new proxies. We're not going to be introducing any new ballots. This is simply to finish the original meeting as it was started, while giving the district time to review the challenges that were made at the original landowners meeting. As you guys probably remember, back at the original meeting, when you guys come in, I write down all of your proxies and all of your votes and all of your ballots. I have all the original stuff still here from the original meeting, as if all the handwritten stuff, as if the meeting has never stopped. But I did hand out this sheet to everybody. All this sheet is with these number of votes received, along with on the back, you'll see the votes received by candidate. All that sheet is an easier version to look at of these handwritten sheets. I didn't add anything new. There's nothing different than what was handwritten back at the original meeting. We just thought that this might be easier for people when they're speaking to be able to reference back to this, rather than me having to call out loud, this person proxy voted this person proxy voted that. So this isn't anything new. This is just a rehash of what we have handwritten since we had time to do it. With that said, we aren't going to go back and redo any of the items that we had done previously. Those items have been done. As far as, approving the election procedures, electing a chair, electing a secretary, all of those items, those have already been done. We got to the point at the last meeting where we had received ballots from everybody who brought the proxies. We had done the ballot tabulations, which again are on this sheet. Back at the original meeting, I read them out loud, but now you have them in front of you. And it was the certification of the results is where everything kind of came to a screeching halt. Challenges were made. We recessed the meeting in order to give everybody time to, the district time to receive all the challenges in writing and to look at them. So at this point, Mr. Berman, you were the chair of the landowners meeting originally. You're still the chair of the landowners meeting. So if you want to, I'll turn it over to our district council who received the challenges and reviewed them so that we can continue on with the ballot tabulation and the certification of results.
Mr. Manager, can you hear me?
Yeah.
Okay. Could I ask you, just for everybody's information, to please go through the record and indicate the landowners that were on the roll, that the public has, as well as the number of their votes, please?
Sure. So at the original meeting, we had Mr. Berman came with 583 votes. Commissioner Jenkins, Martin County only property, was 535 votes. Commissioner Jenkins with South Florida and Martin County jointly owned property was 3,031 votes. Commissioner Jenkins with South Florida Water Management District only property located within Martin County was 1,388 votes, and Commissioner Jenkins with South Florida Water Management land only owned only located in Palm Beach County was 1,246 votes. Commissioner Marino with Palm Beach County owned land was 280 votes. Zach Gaza via proxy was 2,531 votes. Zach Gaza's personal acreage was 15 votes. Robert Hirschberger was 26 votes. Michael Engelhart was 1 vote. Blair Pontac was 1 vote. Scott Pettigrew was 3 votes. Eugene Wise was 3 votes. Susan Witonsky was 1 vote. Patrick Kidney was 1 vote. Tammy Crow was 1 vote. Ricky Morales was 1 vote. Corey Beaton was 52 votes. Brian Gale was 1 vote, and Jamie Weimer was 1 vote, for a total of 9,701 votes.
You're actually, if I may interrupt, you actually missed one person that you read is not on this sheet. There was a woman, I think it was, where? I'm sorry, Susan Witansky. I apologize. I was going
Okay.
over there. Never mind.
Mr. Manager, could you then now go through and proceed with the number of votes that were received by the candidates, please?
By the actual ballots
Other
received?
sheet,
Yep.
the second sheet.
So the ballots received for candidate Zach, there was only two candidates that were put up, Zach Gaza and George Stokes. For Zach Gaza, he received a total of 3,220 votes. And then for George Stokes, did you want me to go through each? Okay. For Mr. Stokes, he received a total of 6,480 votes, and there was one vote by Ms. Susan Witowski for none, which gives us a total of 9,701 ballots received.
Thank you, sir.
Yep.
Okay, well, I think this is actually going to be the Mary Betsy show. So at this point, I'm going to turn it over to Mary Viator, Betsy Burden, which represents legal counsel for the Palomar Water Control District.
Yes, and also with me is Mr. Bill Doney from our office, and we've tried to combine all of our thoughts together and our interpretations, and we've provided an overview that we'll go ahead and present to the board as well as to the landowners that are here this morning. At this point, I think it's important to explain that in considering the multiple election contests that were submitted concerning the recent election, it is the opinion of District Council that the district is governed by both the provisions of Chapter 298, the District Special Act, and the election procedures adopted by the district. In reviewing these materials, it is our opinion that matters to be properly considered by the district, considering a specific contest, are limited as to whether an individual or entity casting a ballot that is being contested is the owner of the acreage for which they voted, and in the event of proxies, whether the proxy documents comply with the provisions of Section 607.0722 Florida statutes. This review has been accomplished. Several of the contests submitted raised issues that are well beyond the scope of these limitations. Whether the legal merits of these contests, such matters would more properly be raised in a judicial proceeding where a full record could be developed and the due process rights and interests of all parties are protected. District Council is of the opinion that it is not appropriate or proper for the district or its manager to be placed in the position of being the arbiter of these types of legal challenges, and they're not authorized under the law. Now, let me get to the specific objections that were received. They were in two basic categories. The first set of objections were received from Martin County and Palm Beach County. And we'll go ahead and talk about the objections as well as the response. So the following, in response to these objections to the election that we received from Martin County and Palm Beach County on June 27. As the attorneys for PalMar, it is our office's responsibility to represent the district and to ensure the election is conducted properly according to law. Our office is impartial and is not advocating for any particular objector. No new objections were allowed after the June 27 meeting. Just the supporting documentation regarding those objections received timely. Any new objections submitted after that date were not considered. The first one was the objection timeliness. Several objections were timely submitted by various parties at the annual landowners meeting. The meeting was recessed to August 22nd, which is today, per Section 8 of the election procedures. Only those objections and proxies that were timely submitted on that date were considered. No new objections or proxies were allowed. Proof of ownership of acreage or supporting or defending documentation submitted by July 5th within the 5 business days of the meeting were considered. According to Robert's Rules of Order and in accordance with the district manager has indicated, once the meeting is reconvened, business proceeds the same as if no recess had been taken. Therefore, only the objections timely received were considered. The second major argument for the Martin County and Palm Beach County, that any objections based on issues other than the acreage raised, assessments paid for the previous year, and proxies are generally unacceptable. Objections outside the scope of election review are invalid for the purpose of reviewing the objections. The third issue was question of de facto officer by Mr. Gaza. Martin County stated in its objections that Mr. Gaza's term expired June 8, 2022. However, Section 298.112 states in pertinent part that supervisors shall serve until their supervisors shall have been elected and qualified. Palm Beach County opined at that same meeting that the governor was required to fill the vacancy in Mr. Gaza's seat. According to Section 114.01, there is no vacancy in this seat. In concluding these particular objections that were timely filed, in conclusion, Mr. Gaza shall serve until his successor is elected and qualified pursuant to the provisions of Section 298.11, as well as the Attorney General Opinion 2010-51, and Attorney General Opinion 78-107, which concluded that an incumbent officer whose term has expired is considered a de facto officer and may hold over until his successor is elected and qualified. His acts in that office are not subject to collateral attack. In conclusion, the objections received from Martin County and Palm Beach County are addressed, and the election should be certified accordingly based on those items. We'll be going through the next set of objections. Note that in the event that the landowners fail to elect a supervisor, there is another section of 298.12 that states that the governor shall appoint such successor who shall hold the supervisor's office for 3 years or until his or her successor is elected. So for right now, our purpose is that there is no vacancy in the office as yet, and that if in fact the landowners, the landowners sitting in this room, if we cannot come to a resolution, then it would go to the governor for a appointment. So those are the first set of objections that were received. Now we're going to the second set of objections that were received, and basically there are 7 objections. Okay. The comments, I'd like to say that the comments I talked earlier about are the same comments that I have with regards to this separate set of objections. No new objections were allowed after June 27th, just the supporting documentation. And it's important to realize that this is in response to the objections to the election received from various private landowners that we received at the annual landowners meeting. The first one questioned was an issue dealing with proxies. There's a specific section under Section 298.11(2) that states that each owner shall be entitled to 1 vote in person or by proxy, in writing, duly signed for every acre of accessible land owned by him or her in the district. The appointment of proxies shall comply with 607-0722. And there's a specific provision under 0722, which is paren 8, and states in pertinent part that a corporation, which would be the district sitting in this position, is entitled to accept the proxy's vote or other action as that of the shareholder making the appointment. And then going on to specific explanations as to proxies under 607-0724, there's 8 provision, but we're going to address just 4 of them because they are just the ones that are applicable. Excuse me. If the name signed on a vote, a ballot, consent, or a proxy appointment corresponds to the name of a shareholder, the corporation is acting in good faith and is entitled to accept the vote, the ballot, or proxy appointment and give it effect as the act of the shareholder. So if we're given something, we are responsible for accepting what was received. Neither the corporation or any other person authorized by it that accepts or rejects a vote, a ballot, or proxy appointment in good faith in accordance with the standards of this section, they are not liable for damages to the shareholder for the consequence of the acceptance or rejection. Corporate actions based on the acceptance or rejection of a vote, a ballot, consent, or proxy appointment under this section is valid unless a court of competent jurisdiction determines otherwise. A landowner contends that the executive director of South Florida lacked the legal authority to execute proxies on behalf of South Florida in favor of Martin County. In favor of Martin County and Supervisor Jenkins. A review or decision on the propriety of the internal policies and procedures of South Florida is beyond the scope of the authority of PalMar. Pursuant to the provisions of Section 607-0722, which I previously addressed, the acceptance of the questioned proxies is appropriate. This is another very important issue and point dealing with the proxies. Section 607-07242 states that if two or more persons are the shareholder as co-tenants or fiduciaries and the name signed purports to be the name of at least one of the co-owners and the person signing appears to be acting on behalf of all the co-owners, Martin County, in this instance, would be entitled to vote the approximately 3,031 acres which it co-owns with South Florida Water Management District. Therefore, PalMar's acceptance of the subject proxies from Martin County and South Florida Water Management District combined with the one proxy, Palm Beach County and South Florida Water Management District is valid under the statutes that were quoted. Item number 2, we have 7 total. For litigation, there was a comment dealing with the litigation of Martin County and South Florida versus Hope St. Lucie and PalMar. And this is recent since our last meeting. On July 20th, the Florida Supreme Court has declined to hear the appellate court decision in favor of Hope St. Lucie. Although PalMar did not elect to pursue the appeal, it remained a party litigant as appellee under the appellate rules. And the rules define an appellee as every party in the proceeding in the lower tribunal other than an appellant. This was confirmed also by the Attorney General's office. PalMar is therefore bound by this decision, even though it has not yet received a final judgment in its favor. One of the effects of this decision is that the subject land, and it confirms that the subject lands of Martin County and South Florida are in fact accessible, which is a requirement to vote under Chapter 298. The next item is the status of whether assessments were paid. Several landowners contend that Martin County has not paid its assessments in full and therefore are not permitted to cast the votes for the acreage in question. The question of the appropriate discounts, penalties in the collection of assessments is a matter within the province of the tax collector and beyond the scope of the election challenge. The tax collector of Martin County advised that the applicable assessments have been paid in full. And the applicable application of Florida statutes and regulations pertaining to the collection of taxes, applicable to discounts, penalties, and interest in matter more properly is within the purview of the tax collector. In accordance or in conclusion for this particular portion of the argument number 3, the total amounts, including penalties and interest, are decided by the tax collector and not by PalMar. PalMar is required by law to comply with certain statutory procedures set forth in Chapters 298 and 197 regarding assessments. PalMar has no specific legal authority to decide the total amount to which it is due and owing. This question is beyond the scope of the election challenge. Number 4, this is the issue that was raised pertaining to Martin County Commissioner. The election contest also questions whether Supervisor Jenkins is in violation of Chapter 112. Chapter 2005-305, the enabling legislation for PalMar, provides for one supervisor seat to be held by a member of the Palm Beach County Commission and 1 seat to be held by a member of the Martin County Commission. It is inherent that holding a seat on the Board of Supervisors of PalMar would have the authority to cast votes in accordance with the acreage owned by Martin County and in favor of candidates viewed. And that's in accordance with Section 112.13. Accordingly, it is not a conflict of interest for this commissioner to cast votes in accordance with the votes of Martin County. And the reason that we're also relying on is that the designated seats on the board are determined by this special legislative act. Item number 5, talking about the need for a declaratory judgment, possible legislative amendment, and oath of office. These issues are certainly outside the scope of PalMar's election procedures. Any decision to pursue legal options is up to other parties for the purpose of reviewing the objections. Objection number 6, the removal and qualifications of a supervisor. There does not appear to be any impropriety that George Stelkus being elected as supervisor. And my response or explanation regarding the qualifications according to the Florida Division of Elections, Opinion 97-04, the district conducts its own elections in accordance with its procedures. PalMar is effectively standing in the shoes of a supervisor of elections and is not required to resolve factual disputes in the face of evidence regarding candidate qualifications. PalMar's rule is likely purely ministerial and not discretionary. It is not to look beyond the face of qualifying papers, or in this case, proof of ownership and proxies, to determine if a person is a qualified candidate. No administrative board has the lawful power to inquire into the legality or validity of an official's election to office or his right to hold such office, and that's per Florida Attorney General Opinion 73-193. Any recourse is seeking legal action where a court would resolve any factual issues. The candidate for the board seat authorized by Martin County appears to be qualified as a landowner and resident of Martin or Palm Beach County. The following, and this is the final objection that was received, was number 7, and it dealt with the improper notice to the landowners. There was a question whether there had been previous notice and procedures from 1991. The district has followed all its state law in providing notice to the landowners at the annual landowners meeting. The notice required by sections 298.12 and 298.11 were timely published, and furthermore, notice of the annual landowners meeting was included in the meeting schedule published as required by section 189.015 and is on PalMar's website. Therefore, the applicable statutory requirements for giving notice were met. In conclusions, with regards to this set of objections, the objections received from private landowners are addressed, and the election should be certified accordingly. So the next step is then going through the ballot results that were distributed by the district manager. Based on the review from our office, the candidates, and addressing first the votes and proxies received by Zach Gaza, we feel that those total votes received for Zach Gaza were properly received in the amount of 3,220 votes. With regards to the total votes received for Zach Gaza, I'm sorry, I was reading on the line. For George Stelkus, the results from the Martin County Harold Jenkins proxy for Martin County only, that was 535 votes. The proxy submitted by Harold Jenkins for the South Florida and Martin County joint co-owned property is 3,031. The proxy submitted by Harold Jenkins for South Florida only, located in Martin County, is 1,388 votes, and the Harold Jenkins votes for South Florida lands only located in Palm Beach County is 1,246. The proxy received from Commissioner Marino for Palm Beach County only was 280 votes. So based on a total for those votes received for George Stokas, the total is 6,480.
First of all, I just want to thank Mary and her firm, Betsy and whoever was involved in the analysis of the objections. Mary is the district counsel for the Palomar Water Control District, and based on, let me, just one second. Has the district received any notice of any type of lawsuit, any challenge legally to the meeting or the election that you're aware of? Okay.
We're not aware of anything.
Okay. And based on that report, then I believe it'd be in order at this meeting to look for a vote to certify the results of the balloting that was done on the 27th.
Yes, sir.
I make a motion to accept the results of the election.
I'll second.
A motion and a second. Is there any discussion?
I have a, is now an appropriate time for clarification on your statement?
Yes, but we have a pending motion.
Well,
What
discussion.
discussion?
So is it?
I think it's appropriate for the chair to allow for discussion,
Okay,
Mr. Chairman.
allowed.
One of the item numbers was about the statutory discount
Yes,
decided by the tax collector.
yes, sir.
Did Palomar receive, maybe Michael, you know this better, did Palomar receive a document or an email or something in writing from the Martin County tax collector that the assessments were paid for the properties that were voted on? Is
Yes.
there a writing?
Right, yeah, so I received an email that said this distribution, which had the amount of the distribution that we received via wire, had an attached Excel sheet that said these are all the properties that are paid by this distribution.
Okay,
It was via email.
I know I probably already have that. Could you forward that to me after the meeting? Thank you. And number two, as far as the landowners not taking into consideration if the assessments were actually paid as per the statute and leaving that up to the tax collector, is there any statutory authority or case law or anything where this has come up before, or is this the first time that your firm has come across this in the state of Florida? I'm sure you've looked into it.
We're not aware of anything.
Okay.
But there is the general case, there's general procedures is that the tax collector is the one that, in fact, prepares our assessment rolls and that we rely on that.
Right.
And then also specifically, Palomar, as we know, is very special. It's special because in 1990, when all of the districts were going to a different type of methodology for the levying of assessments, they had traditionally always done it through Martin County under Chapter 197.363. And that's where the district would submit its assessment rates, and that agreement provided that the tax collector, and we did one with the property appraiser also, would provide our rolls and collect our assessments.
Okay.
So when I mentioned it, I mentioned 298 and 197 because that's the method that our assessments are collected.
Gotcha. So
And
in
at this point,
Yep.
this district would not be in a position to contest that. That's not to say that somebody can't individually go ahead and ask for a determination on another issue or that issue, but that is not for this venue.
So the tax collector provided Michael with an email saying that the assessments were paid, and your firm relied on that email from the tax collectors that the assessments were paid in order to come up with your position. And the research that you've done has shown that there are no other cases, attorney general opinion, or statutes that deal with this issue where the district would rely on just the tax collector for the payment of the assessments.
We're not aware of one.
Okay, so this is, you're going out on the string here, you're going on the hook.
Well, no, we're not, because I think
That's
it's
fine, I got my information, I appreciate it.
in the context of this election.
Yeah. Thank you.
Yes, certainly.
Any other further discussion on the motion?
I have, yeah.
Go ahead.
I'd
Yeah.
like to clarify one question before we vote on it. Commissioner Jenkins is bringing 1,388 votes. I'm just trying to understand how you came to your decision. Of South Florida Water Management so-owned property.
Yes.
And does South Florida Management still owe for some of the previous property in the last year?
I'd have to defer to the district manager, but
So to be clear, when the tax collectors gave us a backup of what properties were paid for by South Florida, they paid for everything that they owned in Palm Beach County. The Palm Beach County distribution was for all properties in Palm Beach County. In Martin County, it was certain acres that they paid for. There are some acres in Martin County that they did not pay for.
South Florida Water Management.
South Florida Water Management, right.
And that's not a conflict to 29812.
no, it is not. But
Okay.
this is not within the legal final determination, but for consideration, even if for those lands that were solely owned by South Florida, by themselves, and in Martin County, and if they were located in, South Florida lands located in Martin County, if you remove those, I'm not trying to change our recommendation, but if you changed and did not consider those, you still would get 3,846 votes for Martin County voting for George Stokas.
I agree with that. Okay, thank you.
As far as the current litigation, which you mentioned, I'm only bringing it up because you brought it up.
Right.
What effect does that have on this election now that we have an opinion
Right.
that's binding on PalMar from what, the appellate court?
Yes, it was from the 4th District Court of Appeals.
Right, and the Florida Supreme Court has now declined to hear the case, so that's it.
That's it.
The case is over.
Zip.
And the decision is that Martin County and South Florida Water Management do have to pay all past assessments and all current assessments and all future assessments. Michael.
Can I read you a summary that we provided? Because I was going to get to that when we get to but I could clarify some of that for you.
Okay, my question is the effect that it has on this election if now Martin County and South Florida are supposed to have paid all their assessments. Michael, have they? Are all past assessments paid?
You're talking about for past years? No, we
As
have,
per the court order.
currently, we have the only assessments that we received were all for the current year. Yep.
So does that have any effect on this election now that there's a court order to pay and they still haven't paid?
Let me just go through and explain this a little bit, because we had our last meeting was on July 13th. This appellate decision from the Florida Supreme Court came out on July 20th. And the Supreme Court, in that instance, declined jurisdiction to hear the appellate case of Hobe St. Lucie versus Martin County in South Florida. The final ruling upheld the decision that Hobe St. Lucie Conservancy had correctly imposed a special assessment, not a tax, against Martin County and South Florida Water Management District, and that Chapter 298 provides that the requisite statute authority for imposing the special assessments, and that gives that to the special district. That indicates, no, that provides that special districts have the legal authority to impose and collect special assessments against these governmental entities. There was a final judgment that was recently entered by the circuit court in the Hope St. Lucie portion of that, and the final judgment was received with a stipulated order that those tax assessments and going forward they're responsible for, subject to statutory requirements. So that has not been done yet in PalMar, but that does not mean that PalMar does not, it was an appellee in this case, and that you, as this district, would be subject to the same. And we were going to ask at the meeting following this that we go ahead and proceed to obtain that final judgment.
That was a month ago. And for the final judgment, you said was July 20th?
No, July 20th was the Florida Supreme
Supreme
Court.
Court, all right.
Yeah,
The final judgment was prior to that.
yes.
Did the final judgment mention anything about Martin County or South Florida not being only being subject to part of the statute, not being subject to discounts or late fees?
Did not address that. It said accordance with statutory provisions.
Correct. And the statute does lay out for late fees of 3% and for, no discounts if the assessments are received after June, or in June or later, after June 1st. That's the statute that I read. Is it the statute you read as well? My concern is that by taking a recommendation, this board would be, or this landowners meeting would be violating the judge's order. Not concerned about that?
Because this election is dealing with the facts as we have them and the circumstances, and it is our opinion that that's appropriate.
Thank you.
Any further discussion? And so I'll call for the vote, and just a reminder that the votes will be based on the amount of acreage that each proxy holder also holds. So quite frankly, I guess we just need to hear from Mr. Jenkins.
We read out the amount of votes that everybody has already received, because we've actually already received the ballots. So the votes have already been received, and per Mary's explanation, all the challenges, the numbers of votes that we received is not changing. So at this point, we just, I believe we're just at the point where we just need to certify. I mean, do you need me to read out who voted for who again?
No, I'm saying in terms of the motion for this meeting
Oh, okay.
and the votes that will be cast on this motion, that the total votes will be the numbers reflected in the proxies. It's
Right.
We're not looking to the audience, we're not looking for a raise of hands, we're just looking for the most votes. So, I mean, it's fairly obvious, should be obvious to everybody, that a person with, 6,200 votes here in this meeting is going to carry the day, so.
Right.
So,
But he's already cast what I'm saying is he's technically already cast his vote. He cast his vote for Mr. Sokas when we did the ballots at the original,
right
when
now
we
I'm talking
originally
about
met.
the motion to certify the election.
I apologize, to certify.
Gotcha. Okay, so, all those, I'm sorry, yeah, all those in favor, say aye.
Aye.
All opposed?
Opposed.
Motion carries. And the certification of the results is completed.
And just for the record, I will provide for the district the objections in my presentation.
Okay.
For the record.
And then I believe all the other items scheduled for the annual meeting were completed on the original meeting in June. So at this point, if there are, well, no, right now we can ask for a motion for adjournment of the annual meeting of the Palomar Water Control District. So
I'll make the motion.
have a motion and a second to adjourn. Any discussion? All those in favor? Any opposed? Say aye. Yeah. annual meeting is concluded. We will now hold a meeting of the Board of Supervisors for the Palomar Water Control District, and maybe take a brief recess in between for 5 minutes. It's 10:40, reconvene at 10:45.
Understood.
Okay.
I'll be here. I'm just going to be.
And if I could ask, I guess, Mr. George Stokas to come on up and take a position here.
Yep, we have proof of by the way, we have proof of publications in your books on page 22, again, for the original and the reconvened. At this point, we would be looking to seat the new board member.
Sorry, just looking for my agenda. What page is it on? 20? Okay, got it here. So, yep. And now we're on item number C, which is seat new board members. Mary, I believe, would do that.
Would you please rise? I'm going to administer the oath of office to you. Do you, as a citizen of the state of Florida and of the United States of America, and being an officer of Palomar Water Control District and a recipient of public funds as such officer, do hereby solemnly swear and affirm that you will support the Constitution of the United States and the state of Florida, and that you will faithfully, honestly, and impartially discharge the duties devolving upon yourself?
I do.
Congratulations, sir, and I have your oath, so I will have you sign this, please.
And I guess as we're doing that, Mike, if you could establish a quorum here today?
Right, we have a quorum. We now have all 5 current board members seated. We have Mr. Berman, we have Mr. Stokas, we have Mr. Loma, we have Commissioners Jenkins and Commissioners Marino. So you have all 5 board members.
Yeah, correct.
So now it would be appropriate to reorganize the board, is typically what we do after we seat a new member.
Yes, and so under item F here, I would accept nominations to serve as chairman of the Board of Supervisors.
I nominate Bob Berman.
We have one nomination. Are there any other nominations?
I'm going to nominate you.
Me? Me?
You can decline if you want.
Yeah, you can.
No, it's okay.
All right.
So are there any further nominations? All right, so all those in favor of Bob Berman serving, say aye. Aye. All those in favor of Commissioner Marino serving?
Aye.
Hi.
Commissioner Marino is elected chairman. We also need a vice chairman, so I'll accept nominations for position of vice chairman.
I'd like to nominate Bob Berman for vice chairman.
Okay, I have one nomination. Any additional nominations for vice chairman?
I think I will nominate George Stokas.
All right. Any additional nominations? Nominations are closed. All those in favor of Bob Berman for vice chairman, say yes. Yes. All those in favor of George Stokas?
Yes.
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 Okay, George Stokas is elected vice chairman. Secretary treasurer, normally, I think all the members of the Board of Supervisors serve as assistant secretaries, and officially, Michael serves as secretary.
Right, to help facilitate the work of the district happening
Recording
outside of
secretary,
minutes.
yeah, those kinds of things. So without objection, if we can elect all members of the Board of Supervisors as assistant secretary and Michael as the official secretary for the district. All those in favor?
Yes.
Aye. Okay. And then, which covers both of those last items there, so.
Right.
Are there any additions or deletions to the agenda?
Hearing none?
Hearing none. H, approval of the minutes. We have two sets, I believe.
Correct.
Can I stop you for a second?
Oh, that's right, I'm no longer in charge, sorry. Well, I just kept rambling on there, didn't I? Yeah.
You've done such a fine job at it, so
Yeah,
no
yeah,
worries.
Yeah, no, it is your show, go ahead.
No, that's okay. So any additions, deletions, or modifications to the agenda? None. Okay, so may I have an approval of the minutes for June 27th, 2020, and July 13th, 2022, as posted in our book and online?
I'll make a motion to accept.
A second.
Did anybody have any amendments to the motions?
We did provide comments to Michael, his
Ye-
office.
Correct. You made some comments after the initial posting. I updated those comments, reposted it, and re-notified everybody, and those comments have already been addressed in these minutes. So these minutes are up to date.
Thank you. Okay,
Aye.
so we had a motion, second, approval? Okay. Did we vote? All those in favor? Aye. Aye, thank you. All right, so now we're down to status reports. So, Mary?
Okay. I'm sure you've had enough of me, but for the legal status report, I'll be reporting, our office will report as they appeared on the agenda. The one item that we did speak about earlier was this issue dealing with the Florida Supreme Court case, which basically provides that PalMar, as an appellee, would be subject to those provisions of that particular order. And as a result, it is appropriate for the board to authorize to request the final judgment to facilitate and finalize that particular level of the proceedings.
Okay, so may I have a motion from a member of the board? Here. Make a motion.
What are we making a motion on?
We're making a motion to accept.
Motion to
Oh,
accept.
the legal,
I think it's a motion to request final judgment in the name of PalMar. Right now, we only have it in Hope St. Lucie.
okay.
What we believe that entry of judgment would be necessary to pursue for the payment of the past NAVs, since it's the direct, and since it would direct the tax officials to proceed and bill the non-ad valorem assessments on behalf of PalMar. It's appropriate at this time.
Question before we vote? In your opinion, is this going to be a process, or is this more of a procedure? Do you have any kind of outlook of how this would go if we voted to?
We've already gone through the same exact process with Hope St. Lucie, and we anticipate having the same exact result as a result of the finalization of the litigation.
Thank you.
Yes.
Okay,
Motion to accept?
I second it.
second, all in favor? Aye.
Aye.
Now, Mary, is there is there a time frame for this?
To do what?
We're requesting the final judgment. Yes, is there a time frame?
Well, the judgment has come down, so now it's appropriate. It's the same exact process that we did for Hope St. Lucie.
Okay.
Whenever the judge signs it, we still have to get a court hearing unless the Martin County and South Florida agree, as they did in the past, and that would take care of that issue.
Okay. So, since we are done with the legal status, anything else, Mary?
No, that's it.
Okay. May we have the engineer's report?
Go along, we'll report.
Yes, I want to report first that in my conversations with the Water Management District about Trailside, the entrance, they pointed out, I thought the culvert that was put in was in the Trailside perimeter ditch, but it's not. It's located in a ditch that belongs to PalMar at the toe of the levee. So it puts it in a different light in the sense that Martin County is pursuing it through code enforcement, which this board should continue to support. But I just wanted to make you aware that there's more to it than just fill that was placed. It's a culvert that's placed on works of the district. The other items of my report are on the agenda. One of them is dealing with sending 298 language to the county and water management district because Corey Beaton did show me, demonstrated that his second set of culverts that he's put in through PalMar's levee was signed off by the water management district. And it's a shame that they don't coordinate because they look at it strictly from an ecological standpoint, and that's a very narrow focus. You got to look at more of the fact that they're depriving the landowners of whatever potential benefits they do get from being within the district. And I'll cover the other items as they come up on the agenda.
Mr. Chairman,
Okay. Bob, you
question
have a
for the
comment?
engineer.
Sure.
And I had the benefit, Bob shared some photographs with me outside the meeting here, and just to be clear, the location of the culvert is not in a part of the plan of reclamation. It's not part of the
Right, it's not in
drainage
a
plan.
canal that's labeled in a water control plant, but it is in a tow ditch, is what I would call it, at the bottom of the levee that captures water coming off from the levee, and that's why it's there. Does a culvert by itself harm the district? No. But where the harm is unknown is it allows traffic to occur from Trailside to Palomar and vice versa.
Okay. So, I mean, in terms of jurisdiction, so this would be an area for, I guess, probably the Property Owners Association, South Florida Water Management District, Martin County, and Palomar. So I don't know the order of priority there, but in order to facilitate this installation, that landowner would need to have obtained permission or permits from at least those agencies.
Well, up until discovering the location of the culvert, I would have said, yes, that's 100% correct. But now that they're in a position where it could potentially affect the levee for whatever reason, you've got a stake in the game.
Okay.
Go ahead.
Where I was headed with this, Madam Chairman, was do we take action first, or do we wait for what I would call the higher authorities, to look into this at some point? I mean, I just don't see the reason for the Palomar Water Control District to get in to the enforcement of this when it may very well be addressed and completed by whether it's South Florida, Martin County, or the Trailside Homeowners Association, one of those.
But wouldn't it be appropriate for us to at least write a letter as our board to Martin County and to Water Management to encourage them to do something about it?
I thought we had done that. I thought we had.
At a prior meeting, I believe that we were informed by somebody with Martin County that they're aware of the culvert and they're already seeking enforcement remedies for it, so.
Yeah, and I think where we were headed with that too was particularly South Florida, if they would somehow, in their checklist for permitting, request or demand that they have some type of acknowledgement by Palomar prior to.
Correct.
Our 298 says that is an appropriate thing. And if you read 298, there's nobody supposed to encroach into Palomar without coming before this board. So as far as I'm concerned, anything that is encroached up to now that did not come before this board is either inappropriate or it's illegal.
So, just talking, I understand that property has now changed hands. The other thing is that culvert is not on that property. Okay, so Is it appropriate for the protecting the works of the district that we actually remove it?
Absolutely.
Yeah.
I don't
culvert-
know why we
The
personally.
culvert is physically located on a PalMar easement.
On the works of the district?
Yeah.
Yes. So it would seem it would be appropriate for us to,
We could send out our maintenance contractor and dig it up
that's,
and remove it. As far as I'm concerned, I don't know.
I agree with 100% with.
Mary, what kind of legal notification do we need for
That's what-
something of this
That's
nature?
my only comment. You have every right to remove a connection to the works of the district that is not authorized by the district, but you should give them notice to say that if you do not remove that obstruction, that you will take the necessary action to remove it, and they be responsible for triple damages. It's under 298.66 Florida statutes.
Okay, and one more question. If we were to do such a thing with this culvert, what is our obligation for anything else? It's under the same circumstance.
same thing.
You have the authority to do the same thing.
Yeah, you do have the authority to remove that culvert as well as Corey Beaton's culverts, because you're dealing with a proprietary right issue with the easements and works of the district, which is different than a regulatory code enforcement.
And, Mary? just
Yes, sir.
Back to you again. So would the notice, though, include the option for that landowner to approach the board and request a permit from PalMar? I mean,
We can't get a permit because it's egress into our,
well, I'm just, previously, we were just talking about a letter of, hey, move it or lose it. But I was just wondering if there was a third option, which would be for them to approach the district and request the permit. I don't know if that's,
That's your discretion. I mean, you can certainly do that, but you do not have to. I mean, you can say that they have an opportunity to come to this board and, to make a request. But under the statute, this board is legally authorized to
Notify the
remove
landowner.
those with the strong recommendation, you notify them, and that if they don't do it, then the district would be able to remove it.
and inherent in that letter would be,
You
hey,
can
come on, talk to us. Because I don't even know who the landowner is. And now it's somebody new, and
I don't either.
they may not have even known what they bought. Who knows? So.
But this follows up on the discussion we had at the last meeting where notification needs to be sent to the surrounding landowners who have the ability to give a permit for any culvert, that they have to notify PalMar.
That's actually an agenda item where we're sending minutes. The direction of the board at the prior meeting was to send the minutes along with language from 298 to Martin County, Palm Beach County, South Florida Water Management District to remind them that they need to include PalMar in any permitting. But we hadn't, up until this point, we haven't approved those minutes yet, so that's why they haven't been sent. So that's actually on the agenda later. I was going
I
to.
see that as item number 5 under old business. Okay. So we can move item number 5 under old business up since we're discussing it now, if that is okay with the rest of the board. Okay, thank you. So now we have to approve the minutes, which we have, correct?
Just did, yep.
Okay. So then, using that, we will now be sending a notice to all landowners that they have to obtain permitting from PalMar, correct?
This says outside landowners.
Outside landowners, regarding outside landowners obtaining a permit from PalMar Water Control District.
Yes.
Right, the board had already authorized that to be done. We were just waiting for the minutes to be done and approved, and they have now been done that. So we'll be doing that between now and the next meeting.
So item number 5 is now taken care of.
It appears so.
Thank you.
so can we go back to so can we instruct our staff to put this trailside property on notice that we will be removing this at their cost? Or however the language that you did, so I'd like to make a motion to have staff do that.
And I'll just remind the board that we can place cost on assessment rolls, but only for those properties within PalMar, since this property is outside of PalMar. Well, we can send a letter telling them they have to pay us, but if they choose not to pay us for the cost of removing the culvert, our only real recourse is to take them to court to get them to pay whatever the costs end up being. So unfortunately, if they're not within the district boundaries, we don't have an ability to assess their property.
There are criminal penalties that could be pursued.
Okay.
Are we only talking about
Put that in the letter.
one culvert
I'm sorry?
The
at
one
this point?
culvert.
This is just the single culvert right now.
The trailside culvert. Yeah.
I think going forward, it's going to be taken on an individual basis as these are found, I would say, discovered. Yes, good word, thank you. So we have a motion. Do we have a second?
Second.
I'm sorry, just to be clear, so the motion is to direct staff to prepare the letter informing this trailside property that we're going to be removing the culvert at their cost. Do we have like a timeframe that we're giving them?
Well,
60
Want to give them
days.
30 days in case we have another, well,
Yeah, 30 days.
30 days? Okay, so
60 till we.
they have 30 days to remove it themselves, or then we'll be out there and we're utilizing our current maintenance contract to do that work.
my only concern with the 30-day, I just want to give the landowner the opportunity to
Make it
show up
60
here.
then.
Yeah.
So we're not, so you're going to do it, not prepare it. You prepare it and do it, right? It
Yep.
doesn't need to come back to us for approval.
Right, so that's why I want to be clear. So the motion is to send the letter giving them 60 days at their cost to remove it or will remove it. And then if we do not receive that, we will have, that's why I was asking, we're using our existing maintenance contractor to go out and actually remove it.
Sure.
Motion amended then to 60 days?
Yes.
Okay. And I did have a second, correct?
Correct.
All right, all those in favor?
Aye.
Thank you very much. So we're actually at district manager report.
What?
The only thing that I have that's not an agenda item is, per our original meeting schedule that we published the entire year at the beginning of the year, we have a meeting scheduled for September 1st. Our September meeting would fall on September 1st. That's about a week and a half away. I'm going to ask the board that, since we're having a meeting today, we can go ahead and cancel that September 1st meeting unless the board has a reason to still want to hold that.
No, I think cancel with notification is fine. Okay.
All right?
Field maintenance report?
I think we did know that, didn't we?
Did we do that?
No,
No?
No, field and maintenance would be Zach.
Oh.
Sorry, what?
Field maintenance?
Want to talk to me? So no one forgets who I am. So, the field maintenance report is looking bleak. The contractor that was hired to go out there and start mowing hasn't been out there. Lou, could you fill us in on the status of that? At the last meeting, it was requested of me to stop mowing. So I did. I went out to look at culverts, and what I had accomplished mowing was already 2 feet high. Lou, where are we at?
Yeah, I agree with you. It's growing fast, and they started mowing Thursday.
Okay.
And they started at off of Beeline. They're going to start the west end and work their way all the way to 7-Eleven, Pratt Whitney Road. So they started mowing Thursday.
Okay. And that's,
Mowing this past Thursday or this upcoming Thursday?
They started last
They
Thursday.
started last Thursday, yeah.
so you said they started at Beeline.
Yeah, they started out at the game crossing gate where the various different homeowners have put a lock on the gate. They started there.
Well, let me rephrase that for you. There are no homeowners out there. There's no development out there, so it would be just be
Oh, did I say
landowners.
Landowners, I'm sorry.
Thank you.
So they started, or you talking about the 150-foot strip? That's the only,
No, I'm talking, they went in at the gate at the game crossing where the.
under the bridge?
Yes.
Are you aware and are they aware that that is not an easement that Palomar has access to? There's no easement there underneath that bridge. They're trespassing.
Wait a minute. So say
You
that,
have your map with you?
yes. Do I have
Pull it
my,
out?
just, what are you trying to,
Well, I want to make sure that these contractors that Palomar hired, number one, know where they're going. Number two, aren't trespassing. And number three, are doing what they said they were going to do for $70,000.
okay, I'll do my best to answer that. I don't think anybody's here. Where are they trespassing at?
Well, you just told me that they started a beeline. And the only access off beeline that I'm aware of is the 150-foot strip owned by Palomar. Is there another access that you're aware of?
Yes, it's the one that the homeowners on that, landowners on that side have been using, and it's down at the bottom. Used to be the old black and white when the new fence went in,
Is it under the bridge?
at the bridge.
At the bridge, right?
Yes.
There's no easement there, Lou.
I have permission from South Florida Water Management to go in there.
Does Palomar have that?
The arrangements was made with Steve Coughlin, and he said that we can access for ease to go through that gate off of Beeline until such time we get to close to 7N, and then they'll start coming in there.
Do you have that in writing?
No, it's verbal. I didn't need it in writing.
All right, well, as the maintenance contractor, do you think it would have been appropriate to let me know that?
I absolutely agree with you 100%, and you and I will be able to communicate from this day on. Before, I can't call you. That's always been a conflict. Well, you and I can, and I'll be more than happy to communicate with you, and I would appreciate it if you would assist me in making sure the job is done properly. I have no problem with that.
Does the contractor still uphold his word that he'll be done in 6 weeks?
You can probably contact them, and I'll give you all you need to answer most of your questions directly to them instead of coming through me. I only put the program together. And because I'm still involved is only to make sure that we mow it per the footprint that was once done, which is the highlighted map. And that has been okayed by FWC, by the engineer. And those guys are using that map for a footprint to what do. Once that's over with and I bring to this board that it is completed at that point, you or whoever's in your position would take completely back over to oversee it, which is fine with me.
Well, I'd like to speak to the whole board. In concern of having too many chiefs here, who would you like to manage the contractor? Myself or Lou? Or somebody else? I don't want to, have any.
Well, it should be a member of the board. So, Lou, if you would take that role on?
Well, maybe I'm confused here. I thought we pretty well had all this cleared up. If our minutes probably don't reflect it, but what I volunteered to do, because I
You're out there more than most
got
of
the
us.
bids together, and then from there I went to coordinating with them. And I had spoken here before about how inconvenient it was that you and I couldn't communicate.
Well, we could always communicate through Michael.
That's too cumbersome.
Oh,
Yeah.
okay.
If you had these same questions and you went through Michael,
If you look at the minutes of the last meeting, in order for the purposes of communicating regarding scheduling of the contractor, I thought that you were going to let Michael know when they were starting, and Michael was going to let me know as the maintenance supervisor. Do you remember that?
Well, I'm not specifically, but if that was the case, which if very well, that may be on me, because Lou and I have been communicating with the guy, originally when he submitted his insurance proof, it wasn't correct. He didn't have it set up correct, so we had to go back to him and have him resubmit it again. We just got that, and then I gave Lou the okay to go ahead and tell him to start. I did not indicate to you once I gave Lou the okay for him to start, once we got the right insurance, so that's my fault.
To be clear, I'm not talking about anything that violates sunshine here. We're not talking about meeting things that can be voted on at the meeting. This is just about when the hired maintenance contractor can start, and as the maintenance supervisor,
And now that we have his insurance and he's been given the okay to start, he has started. And we just need to make sure that he's mowing on the right places.
so this is now my notice that he started on Thursday.
yes,
Good.
I went out there last weekend because he had indicated it would be like Tuesday of last week. So I went out there again yesterday so I could have an answer today. And one of them happened to be coming out the gate while he worked out there yesterday, and he said that they had been there since Thursday. I don't want any kind of conflict, and I'm not trying to take anybody's job, and I certainly don't want to get that involved with PalMar, except for where I'm at now.
You're a
So-
supervisor.
May I make a suggestion that we reassess the mowing contract? And that we consider the work that's been done? And if we do have a mowing contract in place, would that be the person who should be giving us a field maintenance report? I'm looking at Mike, and he's looking at me with questions.
So you're requesting that the mower come to the board meeting? I can't force him to
Well,
come
he
and
should
report.
be able to give us a report.
I can request updates from him via email, but I can't make him come to the meetings to discuss what he's doing. But I mean, if you want,
There
I'll
should be a report here from him,
Yeah.
whether it's in person or you submit it for him. There should be a report of what he has done, what he's accomplished.
okay. I'll ask him to do that.
Yes, Mr. Berman?
Well, getting back to one of the previous comments here, I mean, over the years, I mean, it's been extremely unusual that members of the board have actually even gone out to the property. I mean, and we're fortunate to have Lou, who's just been out there, you know, for years and years and years, and of course, Zach, when he was serving in the position of both a supervisor and field maintenance. But I think any activity on the property would be most properly supervised by the field maintenance supervisor. That's the job. I really hesitate at even requesting that a board member do that. It just, you know, we're here for administration, for policy, those kinds of things. But as far as the activities on the site, I mean, clearly that's the jurisdiction, and historically has always been the jurisdiction of, you know, the field maintenance supervisor. So, and you know, any of us, Lou, any of us are certainly, you know, we can go out there and do whatever we want to do if we want to, but I would hesitate at making that a responsibility of a supervisor. So we should be able to depend on our field maintenance supervisor for
Absolutely.
this type of stuff.
No problem.
Who's our field maintenance supervisor?
Zach Gaza or the company.
It doesn't fall under the purview of our engineer, no?
Typically not, and what Mr. Berman outlined is where it usually typically fell was with the field person, but it was definitely not a board member. It was up to the field people that are doing work out there to do the reporting through Mike, or I get involved with the culverts and those sorts of things, but not mowing.
Well, again, the person doing the maintenance should be giving us the report. And if we now have a mowing contractor, there should be a report coming from them.
Yes.
Well, now that I know that they've started, I'm happy to go out there and monitor everything and come back and report. I'll be here.
Okay?
Good. I think doesn't the agenda have a mowing update on it today?
Yes, it does. That would be item number 3, update regarding, number 4, update on mowing. So we're just working through the agenda in several different ways.
The update was basically to let the board know what I talked about before, which was we asked for his, in addition to the quote, we asked for his insurance proof. He sent it over to us, but it wasn't properly set up, so we had to send it back, and he had to send it. And that's why, because originally we were hoping that he was going to be able to get started within, I think he said at the last meeting, within like 2 weeks, 3 weeks. He wasn't able to do that because of the insurance problem. So that finally got resolved, and we got all that done. And I think I even put a copy of that in the book. Yeah.
Yes, you do.
Yeah, I mean, it was some time. I guess I could look and see, but it was some time after our meeting before I was actually forwarded the contract for signature. So we didn't have a contract for a while.
Right, we couldn't do
after the meeting.
Right, we couldn't do the contract without the insurance.
Right. I don't remember so the date on that was August the 10th. So August the 10th was when this actually started.
Right, the meeting was the 13th, so August the 10th would have been about
Almost a month
almost
late.
4 weeks later,
Yeah,
right?
Yeah, so just to kind of put it in perspective, even for Zach, I mean, the guy wasn't even authorized to start until the 10th.
So, Michael, could you forward me a copy of that contract? It's in the book. I don't have books anymore, Michael. I gave my book to George.
No, this
I've got an extra one if you
is
want.
online.
Online. So is the map in there also?
No, it's simply just the contract and the insurance.
So shouldn't there be a map that corresponds to the contract, so we know where he's mowing?
I can add that as a backup to the contract, yeah.
Yeah, maybe if we add that to the official contract, this way everyone's on the same page, and there's no issues like we had with access through South Florida water management property.
Okay.
It'd be easier for me to give a report if I could see the map of where he's supposed to mow.
That's online. That map's been on, that's been on your website for 2.5 months. The Mo map is on your website.
Right, it was part of a prior meeting with, when we were requesting the quotes, but I didn't add it as an attachment to the contract and insurance, so I can add it as a,
I think it might be a good idea to attach it to the contract.
yeah, and then I can just email you the whole thing.
Also, there's a scope of work that I haven't seen since it was put out there, which I okayed with Bob. So it's
I'll
out
add
there
that too as a
somewhere.
backup, sure.
With any contract, it's good to have everything clean from the beginning, because things are always fine until they're not. So I'd recommend that, especially if I'm going to be giving the mowing report, I'd like to have a strong foundation here.
And I'll back you up anytime, or anything I can do.
You need me for anything else up here?
Nope, thank you. All right, so now we're on to old business. And it is J1, update on the proposed questions for an Attorney General's opinion regarding Palomar Water Control District granting of easements. And I don't think this is something we should even be doing, and I think it needs to go away. But
The board requested to leave this on the agenda at the last meeting, so I brought it back, and I'll let Mary update if there's anything that's changed.
There's been no change.
okay, so we're actually divided on what to do with this, but I would seek discussion if anyone has discussion. No?
Well, I think if we get to the next item, that's going to answer the question.
Okay. Item number 2, consider granting and recording of drainage, utility, and egress easement to landowners on the map over the district's 3 parcels extending from Beeline Highway to Jupiter Grade.
Madam Chair?
Yes.
I guess my question is, if we're leaving item number 1, is there,
I think we're going to intertwine 1 and
we're
2.
going to combine them? Okay.
Yes. Okay. So I will open it for discussion. Go ahead.
I think it should go away, whether that's by a failed vote or however Mary feels that would be procedurally correct.
Well, it really is up to the board. You know, do you want to take the motion and say, well, go ahead and
Well, it's the discussion at hand is whether there should be an easement or not.
Right.
And I know that there's the sentiment on the board one way and the other. So I guess we'd need to make a motion to
You can defer it, you can.
defer it, kill it, continue the discussion presently. So I'll look to the rest of my members to start to opine.
I would like to make a motion to reverse direction on this whole concept of granting an easement and put it to bed once and for all.
And do I have a second on that?
Second.
And do we have discussion on that?
Now, this could be, I mean, if we kill it now, it can always be brought up again. We're not saying anything that,
Absolutely.
Correct.
okay.
So I don't seem there's much discussion, so I'll take a vote. All those in favor of, how did you put it?
I don't remember.
It's to reverse
To
direction.
reverse.
The reverse direction?
And then clarification, that would include agenda item 1 on the proposed AGO question, and then also consider the granting and recording of that particular easement.
Yes, ma'am.
Okay. So all those in favor of Commissioner Jenkins' motion, say aye. Aye. All those opposed?
Opposed?
Motion carries. Okay, so 1, 2, update regarding litigation. Mary, I think we did that
I
already.
think we've done
I
it.
think that's been covered. Update on amended email from Mr. McGillicuddy. I think you covered that previously too, didn't you?
I just wanted to inform the board that the email was sent out. So I went back to the original email that was sent out that was in question, and I sent a reply all to those, which I believe was primarily Martin County representatives. I don't remember seeing a whole lot of other, there's like 4 or 5 people on that email, including the tax collector and some other representatives from Martin County. That email was sent, basically changing the verbiage as the board directed from paid in full to funds received. So that reply all was sent. I did not get any responses from my reply all, so I don't know if people understood what I was doing or what, but it went out and I never got a response, so.
Okay. So we're going to move on to item number 7 then, resolution for the fiscal year budget. And we had 3 different assessments, which actually now that South Florida Water Management District and Martin County have to pay their back assessments, this might be an easier discussion. So,
Well, I'll caution the board, they are required to pay, but the past assessments have not been received yet. So we, traditionally in this district, it is hard to count any funds until they're received.
correct, but we have received for last year.
Partially for last year, yes. Some of the funds have been received for last year, or for this most recent year just ended.
For the year that gave them the eligibility.
Right, the tax bills that went out November 1st, 2021.
Thank you. All right, we have, in our book, we have 3 different scenarios. And we have, and I'm just going to tear the book apart at the moment, so it'll be easier. We have one based on $15 per acre. We have one based on $12 per acre. And we have one based on $9 per acre.
Correct. At the direction of the board at the last meeting, we brought back these 3 different variations. The $15 per acre is actually what was approved back in June. That's what we used for our trim notices that went out. The other 2, the 12 and the 9, really the only changes other than updating our management contract, which is also an agenda item, I believe, on here. You'll see that the changes are in the maintenance the miscellaneous maintenance. Basically, it's just kind of a placeholder for the difference, just so the board is aware, because this question has come up before. For most of our budget items, we simply take what we've paid in prior years and use that as kind of our best case estimate as to what we're going to do in future years. And these budgets are zero-sum budgets. So when the board directs us for certain assessment levels, as opposed to just finding out what assessment covers specific items, we have to have the remainder of the balance, the remainder of the equation usually gets put into either just general miscellaneous or miscellaneous maintenance. It was asked at the last board meeting that the regular miscellaneous not be used as the catch-all. So you'll see that the real main difference between the $12 and the $9 budget is the amount that's in the miscellaneous maintenance as opposed to just general miscellaneous. As a reminder, with these budgets, when we get audited, we don't get audited on a line-by-line item basis. So if any particular item comes in under budget or another item comes in over budget, really they just look at the overall total expenses versus the overall total revenues. The budget just kind of gives the manager a guideline for what can be spent normally without having to come back to the board and say, hey, if something gets kind of out of whack, then we know that we need to let the board know if something's going drastically out of what the budgeted line item was.
Madam Chairman?
So I know it's hard to do a budget when I get what you're saying, but for the county or South Florida Water Management to default on what they've been ordered to pay is kind of silly. So I personally think that it ought to be the minimum
The $9?
$9 or less.
And to that point, Commissioner Jenkins, if we were to receive full funding for the past years that are still not been paid, which is, I think, 4 years of unpaid assessments, This board would be looking to come into about 500,000 in assessment revenues for those past assessments due. So that's what kind of number you'd be looking at if that's what we were to receive.
Thank you.
Question.
Yes.
Mary, have you had any indications of the intent of Martin County of what they plan to do?
I can only relate to what,
Mary, talking to the microphone.
thank you. I can only refer to the comments I received from the district manager, and he has indicated that they have requested confirmation with regards to the assessments for at least 2020. That is
So-
in the works, it's my understanding.
So, yeah, so to update the board, the Martin County Tax Collector received a final judgment related to Hope St. Lucie. And when they received that, they contacted me directly to say that they were going to redo the bills, the 2 year, just as a reminder to everybody, of the 5 years that had previously been in default. The assessments were actually only showing on the original 3 years. Martin County Tax Collector, without the permission of this district or Hope St. Lucie, removed the assessments before sending out the bills for those two districts in 2020 and 2021. Now that the tax collector is in receipt of the final judgment, the tax collector sent me a form to sign to reapply the PalMar and Hope St. Lucie assessments back to those 2020 bills and the 2021 bills, so that they could resend out those bills to the landowners. I asked the tax collector after I signed the documentation to verify what the amounts were for those years, the rates were for those years, if they knew what kind of due date or when those bills would be going back out with the updated amounts on there. And the tax collector at that time, which this was a couple of weeks ago, did not have a date certain. She did not know that information. So those bills have been updated. I believe if you look at the tax collector's website and you go to, say, 2020 and look at a South Florida Water Management District owned land in Palomar, the assessment should be on there now, as they were not previously. But as far as when South Florida is going to get that bill or what kind of due date that bill will have, that I do not have. I do not have that information. The tax collector also did not have that information when I asked.
Thank you. Mr. Berman.
And number one, I favor the lowest possible assessment that we can do, whether it's 9 or even lower than that. But I just question, does it make any difference, Michael? For several years now, we've been addressing the budget, showing what a payment would be if all assessments were paid. And then you had a separate category here called uncollectible assessments. Is there any reason, is there any, what's the pros and cons of not continuing to do that? You didn't do it in, right now I'm just looking at the $12 one. I guess they're probably all the same. But so why wouldn't we have a budget that assumes now that all assessments are going to be paid?
Right. So back in June, when I presented the original budgets for the trim notices, I presented two different budgets. One was $22, which had the assumptions that we still weren't going to be collecting, because at that point we did not know whether, while we had received the monies so that the county could vote, we didn't know to what extent we'd be receiving monies in the future. So I presented a $22 budget, which showed those estimated uncollectible amounts. And then I also brought the $9 budget, which assumed that all amounts were going to be collected. So it did not have that item on there. At the June meeting, it was requested to kind of split the difference, just to kind of send out the trim notices, and that the board requested that I bring back the budget for future discussion at a future meeting to decide if we were going to keep it at the 15 or go even lower than the 15. But it was decided in June that I did not need to show those uncollectible amounts anymore, based on going forward with what's all happening with the lawsuits and what have you.
Well, I'm not sure that answered my question, because why wouldn't we, on the very first line item on the budget, why wouldn't that number be, whatever?
We are collecting?
Is that, I'm sorry, is that number $9 times 22,000?
Right.
I didn't, okay.
Correct. So now up in the O&M assessments, we are showing we've always, what's happened in prior years is we've always showed the full collection based on the assessment. We put in as a disclaimer that there was a certain amount that we were expecting to not receive. So so in these budgets, we're still showing the full amount that we are assessing. We just removed the amount that we expect not to receive because we are now expecting to receive it, and time will tell. And the idea being that we can reassess that after next year. We have funds available in the bank to cover any shortfalls we might
No,
have.
that's the liability of trying to do math in your head, so, no, I got it, I got it.
I think we're good. So there seems to be a consensus on the board here that we go with the $9 assessment per acre fee.
Can we not go lower?
You want to try for?
No, I think 9 is good.
I'll also remind the board that this, in prior years, back when we used to, as you guys may remember, when we originally were not collecting assessments because we had the settlement lawsuit money from, what's his name?
From the MacArthur?
MacArthur, yes. So there were several years that we didn't bill assessments, and then we decided to slowly start bringing assessments back because we depleted our funds, and we started at like $3 or $4 or $5 an acre. Unbeknownst to us at the time, if it falls below a certain threshold, if the assessment throws below a certain threshold, the tax collector won't even send out a bill. So I want to say that doing the math at that time, you needed to have at least like a $7, $8, $9 assessment just to get a bill sent to everybody to make sure that it was enough to meet the minimum requirement. Because some people only own half an acre or a quarter of an acre. So if the minimum threshold's like $5 to get a bill, you have to be, plus the ad valorem, you have to be closer to a $9 assessment in order to get that bill sent out, so.
No, that was exactly the number. As a matter of fact, it was $5. It only affected quarter-acre parcels, but at that time, there were still 2,000 quarter-acre parcels or something. So, and the regular ad valorem portion of the Martin County bill in particular wasn't enough to make up that difference. So a lot of people didn't pay it, didn't get a tax, or didn't have to pay a tax bill. I think the $9 does it. I mean, that's still only going to be here goes the math in the head thing, but less than $2.50.
Right, and I want to say
PalMar.
that $2.50 from PalMar plus like the $2.50 from ad valorem will hit that $5 threshold. Because I think we did the math before, and it was around $9 that we had to get.
The other thing I think I noticed from Martin County is they did increase the assessed valuation on all the property. I think it's $2,000 an acre now, so even on a quarter-acre parcel, should be enough. Yeah, okay, well, good at 9.
Well, when we went out with the trim notice, I mean, it said we could charge a max of 15, so now we're moving it down to 9.
Right, correct.
And this needs to be done today. We backed the math out of how many of days that we could do it, so it needs to be decided today. So I think is there a motion on the table for 9?
Make a motion for 9.
Okay, so we have a motion and a second for 9. All those in favor at $9, say aye.
Aye.
Okay. Motion passes. Now, if I can find my agenda, we'll go to the next item. Okay, now we have new business on the agenda. Consider approval of updated Special District Services, Inc. management contract that would be moving from $24,000 to $36,000.
Right, that was the discussion prior meetings, to move from 24 to 36, and this contract basically just reflects that 36. The other items in the contract that we also get paid for, like the assessment roll and website, none of those amounts changed. This is strictly just a change to our monthly management contract.
Okay, do I have a motion?
The wording of that is the same contract did I read somewhere in there that the wording is unchanged per your previous contracts, as far as just?
I mean, I think there might be some wording changes that have updated just because the original contract was 15, 16 years ago. So I think we've just kind of updated our contract verbiage over the years. But there's no substantial changes. We're still doing all the same stuff that we did before. We didn't add or delete any of our duties or tasks or anything like that. Yeah.
Thank you.
And Mike, what are tasks 7 and 8? I don't know what those are.
So in all of our standard management contracts, we can assist the board if they decide to go issue bonds. So bonds for infrastructure improvements. So that just lists what our fees are if the board chooses to go forward with the issuance of a bond. Those are our fees to do those tasks that are related to bonds only. So those only occur if the board decides to go out for a bond.
And that's task 8 would be just the reporting of that?
So when you go out for a bond, you are required to put together a methodology report, which says that the debt assessments that will be incurred by the bond that you're taking out are going to be paid by the landowners in the district. And that methodology report says, is everybody paid equally per acre? Are there some stratus of landowners that pay and some that don't? Usually it's based on the benefit, which would be determined by the engineer's report. If only certain lands are going to benefit from the improvements being done, then those lands would pay for it and other lands wouldn't. The methodology report gets into who's paying and how much they're paying and the methodology in which we use to assess those people.
And correct me if I'm wrong, but the tasks that you have listed here, you probably have in every other contract you have with a special district.
Right, this is our standard special district contract. And like I said, we didn't change anything with the other things that you guys pay for in addition to our monthly management fee is the assessment roll and the required websites that they changed a couple years ago. We're required to have them now. Those fees are the same as they were prior. The only thing that we changed was the monthly management fee.
Thank you.
I wasn't concerned. I don't think that the likelihood of this district issuing bonds is pretty slim, but we would be pre-agreeing to pay these amounts. That was my only concern.
Correct. Those are our standard fees if we're going to do the work. Now, theoretically, you could go out and hire somebody to do the methodology instead of having us do it. We offer it at this rate. If the board so choose, they could go out and request, proposals from there are other entities that will do methodologies in addition to us. We're just letting you know that this is our standard rate if you choose to use us for those items.
And this contract does carry what I believe is a standard language for all of our vendor contracts, and can be terminated with 30 days' notice.
Right, 30 or 60, I forget what the exact one is. But yes, there is a provision for cancellation.
Move approval.
It's 30 days.
I have a motion and a second. All those in favor, say aye.
Aye.
Okay. You all are in place for another year.
We're at 30 days.
Oh, there you go. Whichever comes first. No. Thank you very much. Second item on new business would be the considering approval to move future meeting dates to the Martin County Commission chambers and hiring law enforcement. This is...
I received this as a request after the last meeting. Prior to this meeting, this was asked to be added to the agenda. Basically, the board has already approved a meeting schedule for next year. That meeting schedule that we advertised at the beginning of the year has the dates and the locations and times. Currently, those locations and times are the Old Jupiter Town Hall at 9:30. It was requested that we bring up to the board the possibility of just having all the meetings here going forward.
Has anyone spoken with Martin County about the availability of this room on our meeting days?
Well, the Martin County Commissioner's the one that requested it, so
Oh, okay then.
that happened.
All right.
Can I make a suggestion, just in case by chance, I know it just came to me right now, that the Martin County Commission chambers and/or potentially the Blake Library, which we've had a number of actually we used to do the landholders meetings in the library, so if you just add that to the...
Right, if the board chooses to make the change, then yeah, we can update the notice. The notice can't say one or the other. The notice has to be specific.
But what we have done for some of our other districts, in the event that the commission chambers are not available, it would be held at the Blake Library.
Right, in those cases, we would have to send out a new advertisement. So the way that it works currently is we can send out one advertisement for the whole year, and as long as nothing changes, we can hold those meetings or cancel those meetings with no further cost of re-advertising. If we make any changes from what's in the original advertisement, we have to send out a new notice to the papers. So what I would say is we could put the commission chambers as the meeting location, because we can't specify two in the overall yearly advertisement. We can put the commission chambers, just know that any time that we can't have it at the commission chambers, we'll have to send a new notice to the papers to let everybody know that we're changing it to Blake Library.
Well, we've had so many changes this year. I think that would be fine.
Yeah, this year we have had a lot of changes, yes.
Mr. Berman.
I don't have any objection to moving the meetings here. However, the second part of that, hiring law enforcement, we've had law enforcement present here at the last couple of meetings. Has the district paid for that?
Currently, no, we have not requested the law enforcement, and we have not paid for it. I don't know if that would change if we make this a regular thing, but so far, the district has not paid for any law enforcement.
I would have never crossed my mind. I mean, we have bailiffs that work for the county, that support the county. I didn't realize, is there any? I'm not aware of it. I don't think there's any fees for that, and
No, we have not received a bill at any point, because we haven't made the official request yet.
I can't speak for my board, but I can't imagine that we would charge for
Okay.
the county. No.
Yeah, well, I just,
Although I'm speaking for the sheriff, though, aren't I?
yeah.
Nah, he doesn't care. He's good.
I just didn't think it was necessary to hire law.
No, I agree with
Part of the motion, or part of the consideration.
So it would be the consensus then of the board to move our meetings here. That's what I'm getting. And also, if this meeting chamber is not available, it will be at the Blake Library, and then it would have to be noticed.
Yep.
But since we did, like I said, since we've done so much noticing this year, I don't think it'll be a big burden for next year. Okay.
So the updated motion would be to consider approval moving all future meeting dates to the Martin County Commission chambers, with the understanding of Blake Library as a second option if chambers aren't available.
Correct.
And
Does that mean we're changing the time at which these start?
so currently, we're advertised for a 9:30 start for all of our meetings because it's down in Jupiter. I don't know if you want to try to keep the 9:30 meeting or if you want to keep them all at 10 like we do. We've always done 10 up here for the landowners meeting just because we had quite a few people coming from down south. I don't know what the mix is now for people coming to the meetings, if a lot of them are still in the Jupiter area or if a lot of them are maybe up this way and this is actually closer for them. I have no idea.
If everyone else doesn't mind, 10 o'clock is fine for me.
That's fine.
Oh, Bob,
I mean,
you okay?
Earlier better, but yeah, 10's okay. It's okay.
Okay.
All right, so we will leave them at 10 o'clock here.
Okay, so the motion will be to move all future meeting dates to the Martin County Commission chambers, Blake Library as a backup, and we can strike the hiring law enforcement. We're just going to use whatever
Please.
law enforcement is around.
And I guess that's my motion.
That would be your motion.
Okay.
Second.
Okay.
So we had a motion and a second. All in favor?
Aye.
Aye.
Thank you. Okay, new business item number 3, discussion regarding invitation to participate at the South Florida Water Management District Resiliency Coordination Forum meetings. That's a mouthful. Did we get a request for that? How did this come about as
I saw it in here somewhere.
an agenda item?
Right, it was forwarded to our office.
What page is it?
Was it Mr. Higgins? Is that from you?
Page 64.
Point out that I looked at the schedule that they're talking about, and it's only like 2 or 3 meetings. So I'm ambivalent as to whether or not we need to participate because there's no physical infrastructure within PalMar that we're going to need to shore up for rising sea level, et cetera. So it's up to the board.
I mean, the "we" in this would be Bob, I'm assuming? This was invitation? I mean, I'm just, were you planning on attending these in any other capacity, Bob? Would you be there anyway?
No.
Okay.
But I'm guessing that we have representation from either Martin County or Palm Beach County anyway, so we could always get, I don't think we need to saddle ourselves with another meeting, and we could always get a report from Martin County or Palm Beach County, because both of our environmental resources managements and our resiliency departments attend. And I don't want to assume, I do have someone, anybody from Deb?
I got mine shaking her head.
I got thumbs up from both. Okay, so this is not something we need to add to the responsibilities of the district. We can get a report from Martin County and Palm Beach County. Thank you. Okay, item number 4, update the board on FWC invasive plant treatment. Anybody from FWC want to address the board, or who's going to give us a report? Thank you. Dr. Reinhardt?
What it is that there's a couple of areas that are not contiguous to the main part of the Hungry Land. So they're just notifying us that they'll be going into some different areas within PalMar.
Yeah, that's correct, Bob. At Mr. Guy's request, I submitted an email to Mr. McGilliot and just to outline the paths that our contractors would take. These parcels are not contiguous with Hungry Land. They're not accessible to the public, not used by the public, but they are part of our management plan with the South Florida Water Management District to try to maintain and control exotic invasives. And so they're on a 3-year rotation, is my understanding. So this is year 3 or year 1, however you want to look at it. And so we are going to access through 7N and over near the grade. A map was provided. Again, those contractors have GPS when they're out there, so we can review their pathway to and from and while they're on property owned by the South Florida Water Management District, just to, again, for maintenance of exotic invasives, which we feel is a benefit to all of Palomar for controlling invasives on those properties that we manage. So that was just a bit of transparency and coordination with your engineering and maintenance department.
Thank you.
Yeah, I don't see any problems with it.
Much appreciated. Thank you. Okay, item number 5, update on conversation with FDOT and South Florida Water Management regarding flooding caused by Beeline Highway project.
Yes, I contacted the Water Management District, and apparently they'd already worked with DOT 5 years ago to look at the pine trees that are dying off in the western part of Palomar, and have learned that they're dying off because of the boar beetle. And the boar beetle is usually a mature pine tree can shed boar beetles, but whenever they become stressed, they get attacked, and that's what has happened here. And the question is, what caused the stress? And stress likely is wet feet. Is it a threat to Palomar Water Control District? No, but it is something that's probably already happened. So I'm not sure how far you want to pursue, any corrective action, but like I said, more than likely the damage has already been done.
Thank you. Mr. Berman.
Well, I thought the issue was that currently, under the way the widening of the Beeline was done, that there were no provisions made in that plan to collect runoff from the newly constructed highway, and that water goes unobstructed into it's partially or mostly private property, but there's some property there owned by Palm Beach County. So that property is being flooded and artificially flooded because there previously was a perimeter dam, dike, something along there. That was removed. There now is a couple of ditches, if you will, and then another berm, but that berm is penetrated by some culverts which allow unobstructed drainage into those properties. So I thought the purpose of the tree thing was the evidence, but the problem is that no consideration was given when that project was designed and constructed to mitigate and redirect, that runoff. And as we heard at the last meeting, and I have heard separately from independent property owners, it's a big problem. There's a lot of water that is being directed onto that land. At some point, hopefully, maybe in the future, when PalMar gets around to doing what we're supposed to be doing, and that's get a new drainage plan, we shouldn't be having to accommodate the drainage from that highway. So that's the issue, is what can be done, what PalMar has any authority to do, what any kind of influence we can have on correcting how that water is handled. And it goes all the way, it's almost entirely the Palm Beach County portion of the property. I'm not sure how it affects Martin County, and there's no private property owners up there anyway, but that was the issue. So it doesn't sound like that's even been discussed, maybe.
Well, saying that the water goes unobstructed into PalMar is somewhat incorrect. They put in water quality treatment areas, and the water goes into those areas first, and then it overflows into PalMar. Is it the same, or does it replicate what was there before? No. But it is a system that's in place. I'm not going to say that it's equivalent. I don't know. I didn't look at it that close, but getting DOT to change it into something like a canal or a ditch or a swale going all the way along Beeline, that's not likely. So, I mean, I can pursue further discussions, but I'm not sure of the outcome.
Well, I mean, I'd be in favor of at least further discussion because I'm not an engineer. I don't don't plan on spending time doing that. But I mean, I get the reports. I think you've gotten the reports. So we've had landowners appear at our meeting that have provided the reports of what is physically happening out there. So this is boots on the ground. This is stuff, and I think even some of the aerial photography over the past couple of years has kind of substantiated that as well. So, what can be done? I don't know. I mean, DOT came back and put in new, turnouts and driveways and stuff where they were supposed to begin with, and that was done. So I'm not at all convinced that there's not at least an avenue for progress on this, and I believe the landowners are entitled to it. There's at least 9.
I would think a continued discussion with FDOT would be warranted.
That's fine.
And a
I
question,
didn't want to push it too far without first bringing what I found out to the board, that it was the boar beetle that caused the loss of pine trees. But let me continue, see where it goes.
Is this a PalMar problem, or is this a problem between the landowners, DOT, and South Florida Water Management?
Well, I'll tell you, I mean, this could come full circle to why in the hell didn't DOT come to Palomar and ask for a permit? They didn't. We had no say in the design of that project. It definitely influences the property, and it would clearly influence any potential future water management plans for the area. So, if anybody needed to come here, they ought to get the same letter that the guy over in Trailside's going to get.
Send it.
No, that's getting carried away, but that's my point.
I don't know if you're that far off base. Send a letter.
I think further continued discussion is warranted. Did you have a comment, Commissioner Jenkins? No. Okay. All right. So that would be that direction from the board would be.
Direction of the board, have Mr. Higgins continue to discuss with
Yeah.
South Florida and FDOT on the issue
Correct.
of additional
I think
water.
these are issues that would fall definitely under his purview. Thank you. All right, administrative matters, financial report.
This
We
one item.
we got one more item, item number 6.
Oh, I'm sorry.
That's okay.
Yeah, height, spelled H-I-E-G-H-T? Sorry. I can't help it. I wasn't an English major either. But update on Palomar Water Control District perimeter berm height requirement.
was brought up by Commissioner Lomau that the perimeter berm is being graded, and it tends to have a tendency to bring it down lower. There's nothing in the water control plan that specified the standard levee height. I came across some calculations that showed they were calculating berm heights based on internal 100-year floods, where really the purpose of the berm is to keep water out and keep it from coming in. So a normal design standard would be to design the levee height for a 100-year storm occurring on the other side of the levee. but that's not been done. So the only thing I could say is trying to maintain whatever is there today is proper. But is it designed to a specific height? No.
So if we were to take the 100-year storm example, what do we need the height of the berm to be?
Well, it's going to vary throughout the district, but generally speaking, you're going to have a levee that's going to be at least 3 feet higher than natural ground.
And what would be the current status of our berms now?
From what I can see, it varies throughout. I don't see any set height that was established for the levees. And in the way they were built back then, it was more of a question of how much fill do we have available to put on this levee, and that's what went there.
Lou, you look like you have questions.
The reason we got to this at the last meeting is I was questioning whether it was appropriate for the landowners to be grading the works of our district.
It's not appropriate.
Zach seems to think, and he didn't, we didn't get into it, but he gave me the impression when I asked that the landowners do have a certain right. If they don't, then our board has to look into maintaining that no matter what. So I think we need to look at that. If it continues the way it is, we're not going to have a berm. Not going to happen. If you drove out there 10 years ago and seen it was only big enough for a pair of tires to go down the top of it on a pickup truck, and now you can pass on it, and a lot of areas are low. So either it's being damaged by people outside the jurisdiction, which 298 does address, or we may have to pick up the responsibility of maintaining it. It's going to come to that eventually. We can't just continue to let it continue the way it is. Right now we have, I've seen 2 different drags out there that have dragged the perimeter by the landowners. And I did caution one of them that they were on the works of the district. End of conversation, do what you want to do. But eventually, we're going to have to address this. It's the berm is getting lower and lower. And as I understand it, Zach did grade it one time, and he, with the permission of, with the engineer, correct? When you graded the berm?
Yes.
Okay. So we've already been involved in the grading of it one time. That didn't come through the board, though, did it? Was that just a conversation between you and the maintenance contractor?
Just through me, yeah.
Okay. So we've given permission to grade at one time already. So the berm, in a nutshell, the berm is being degraded. It's also getting very soft in a couple spots. And as it gets soft, there's been some other attempts to stabilize it that we're not doing. So eventually, we're going to have to look at it.
Thank you. Mr. Berman.
Yeah, Madam Chairman, I believe there's 2 issues here. So the number one issue is, and I think the question that came to us originally was who owns the dirt? And it's certainly my opinion, not a lawyer either. If the dirt's on private property outside the easement, it belongs to the landowner. If it's within the easement area, it was part of the plan of reclamation, it was constructed at the same time, then that is the jurisdiction of the PalMar district. So that's number one. Number 2 is, who's maintaining this, who's fixing this? So I shouldn't say the only reason, but a major factor in why this hasn't been done for a long period, at least for 5 years, is the lack of funding. And so what I'd like to anticipate is that once we receive all of the required past due assessments, and we can operate on a legitimate, foreseeable budget, that the big change to our budget is going to be in the area of maintenance. And so rather than spending $12,000 a year, we could be spending $100,000 a year. And that money would go to, at that point, because that's still months away, it would be first correcting whatever needed to be done, and then secondly, maintaining it to the specifications that it's been corrected to. So, I think in the meantime, it'd be worthwhile, should be worthwhile maybe, to have Bob at least start on the calculations that are going to be necessary to determine what those heights are. If we don't know, if they're not specified now, we don't know what they are, that would be the first step in this process of reclaiming and maintaining those areas. So I don't know if that's a motion or we can agree, but my suggestion would be to have Bob start the process of detailing those specifications, and then hopefully in a future, hopefully a fairly near future meeting, we'll be in a position to amend this budget again and provide the funding that may be necessary to go out and fix this stuff, and then also maintain it in the future. So that's my take on it.
I'm in agreement. Yep. I think that is a consensus of the board. I like that. I like when everybody shakes their head in one direction, and it's all the same direction. Thank you. So okay, perfect. All right, so now I can go back to administrative matters and financial report. And I do have a question about some wording in the audit, by the way.
Oh, okay. So the financial report is in your books on page 68. If you guys want to give that a look over, I'll just remind the board that at this point in the year, typically we aren't receiving any more assessments. I'll let the board know as soon as if we start receiving any of the back assessments. Again, I don't know when to start expecting that, and typically with both Martin County and Palm Beach County, we don't get a heads up. We just see money in the bank all of a sudden. So we'll keep a track on that. But other than that, the financials are here in the book. You'll see at the bottom, kind of the important part is, as of the end of July, we had $376,000 in the bank. So obviously, we just signed a contract for just shy of, or just north of $65,000. It's a little more than $65,000 for the mowing. So between that and whatever other monies we spend from now to the end of the year for normal operating, we're still expecting to be in the high 200s as far as funds available in the bank at the end of the fiscal year. So we'll have the healthiest starting balance for next year that we've had in a long time.
Thank you. And so we don't have to consider any invoices at this time?
No, the invoices are on the next page, 69.
Thank you. Oh, I'm sorry. The audit, which there is a comment in the audit by the auditor, and since they should be know what the works of the district are. On page 4 of the audit, last paragraph, these assets are used to provide services to residents. This is a reminder, there are no residents in there. There should be no residents in there. There is no building in there. So I don't know why they would use the word resident in here. This is supposed to be a passive area. It is supposed to be a little bit of water storage. It is supposed to be environmental, a little bit of hunting. But there are no residents, and there should be no residents out there. Am I correct?
You're correct. I'm assuming that's just the auditor's standard language for homeowners or landowners. So I'll have them correct that in future years to reflect the term landowner instead of resident.
Thank you.
And my guess is that since we've had the same auditing firm for something like 20 years, it's probably been in there for 20 years.
Right. Like I said, I'm sure that is standard language for them. That's just what they normally use. So I'll make sure that they correct that language going forward.
Thank you. I appreciate it. Okay, so we do have some invoices to approve. Do I have a motion?
Motion to approve?
Second.
All those in favor? Aye.
Aye.
Thank you. All right. Item M, landowner items.
Any landowners wanted to come up and make comments? Here. You just come up to this microphone right here and just let me know what your name is. Tammy Cray?
Yeah. I just have a couple of,
And you have 3 minutes, correct? We have 3 minutes for each. Is that what we do here? Okay, thank you.
okay, so starting now. So there are some letters going out to landowners right now with verbiage using, you can't have chairs, you can't have grills, you can't leave a camper out there, you can't do this, you can't do that. So I go and look at these sections and look for this verbiage in those sections of land development regulations, and I'm not seeing it. So I just want to ask, are these perceptions of how you want to read these before sending out these letters? And also, a comment just made, should be no residents. I don't live out there. However, where does it say residents are not allowed? People are not allowed to live out there. Where's the law that states that? That's all I got.
That's a zoning issue.
Yes, so
And-
interim zoning. So that's a zoning issue. So interim zoning, when is this property going to get zoned? That's the goal, right?
So,
Zone the property?
so to be clear, PalMar did not send out any letters. I'm not sure who you received those letters from. I'm assuming Martin County.
Yes.
Okay, so that's not us. This board is not Martin County. This is PalMar board, so that might be a question for Martin County. Also, PalMar has no zoning authority. We're not allowed to do any zoning. That, again, also is Martin County. This board can only deal with the purviews of the works of PalMar. So unfortunately, those are out of our purview.
Okay, so, but this board said there should be no residents, so where does that come from? The should be no residents part, where does that come from then?
Well, I don't even think we said that.
No, she did.
I said, no, I said there are no residents, is what I said. I said
said
there are
there's
landowners.
Right,
Right.
the current term is landowners because there are no approved residential buildings in PalMar.
Right, and I get that. However, she said there should be no residents. That has nothing to do with land development. Somebody could live in a camper. You know what I mean? I think I'm being pretty clear.
Yeah,
Where
no,
is
I
that-
think.
where is the law, where is there anything that states nobody shall reside out there?
You're being perfectly clear, and I think all of us understand it. I think what's hard to understand, and always historically has been hard to understand, is the extreme limitations of this district.
Right.
We got one job. We got one job, drain the land. That's it. Have nothing to do with zoning, has nothing to do with land use, has nothing to do with permits for how, pole barns and stuff, which, by the way, I see Martin County is starting to permit apparently. So, but I think your discussion, your questions need to go directly to Martin County primarily,
Martin County's.
or Palm Beach County, whichever county you're talking about. But, this looks like government, it's
We have very limited.
got that feel to it,
It's the
but
works of the
good
districts, that's
God,
our
it's,
responsibility.
it's pretty far from
Martin.
general purpose. Well, it's just not general purpose governing. That's not what we do, and so, I don't even think we're influencers, if you want to call it that. We got nothing to do with it, when property owners come to us and say, hey, I want you to drain my land, hey, you're coming to the right place, but beyond that, yeah, all that stuff, yeah, I get it, yeah.
I'll go to Martin County zone. Thank you.
Thank you. Do we have any other landowners or folks from the public that would like to speak? This is the guy
Here's your friend.
this is the guy that yelled at me. Threatened me last time.
I just asked people to sign in to fill their names.
Yep, good.
Are you landowner or
Landowner.
public? Landowner? Okay.
Yep.
What was the name?
Jorge Rodriguez.
Jorge Rodriguez.
Yes, sir. Now, this is about my fourth time that I come to one of these meetings, and we were addressing the issue with the FDOT, and I don't think we have been addressing it at all. I mean, it's the beetle. I mean, the beetles have come in and they taken down the pine trees, but the runoff coming off Beeline there doesn't stop. So the fact that water is coming into my property, who's going to resolve that? Because there's pipes And I'm not talking one or two, I'm talking there's a row of pipes going down Beeline, going into these private properties. And that's government-owned road there draining into private land. That's unacceptable. And the meeting here is supposed to be taking care of that. And it's been going on for 6 years since I've owned this property, and now they're saying the beetles. The beetles is not the problem that I care about. It's those pipes draining into my property that I care about. How are they going to resolve this? Who's responsible? Because it's been going on forever.
And that was the question that we are following through with. It's not a final. We have to continue the discussion. But it is government. It is the Florida Department of Transportation. You have to just keep knocking on their door, and that's what we're doing.
I mean, like they were saying, they put pipe in certain or culverts in certain properties, and then they left. My property doesn't have access off of Beeline, yet they're allowed to drain into it and do whatever they want. It's
Well, we're
we
continuing
get
the
the
discussion.
FDOT out here and be at the meeting or do something about it because it's ridiculous.
We'll have our engineer invite them.
All right.
And George, you're witnessing the amazing speed of government.
Well, yeah, but it's ridiculous.
And I agree.
This is 5 years and it's.
Yeah, yeah.
The FDOT doesn't even show up and say, hey, we're going to resolve this or we're going to do something about it. It's just, oh, we'll talk to them, we'll talk to them, and nothing happens.
Do we have any other landowners that would like to speak?
Gaza, 2 Z's, right?
All right, has my 3 minutes begun? Sure. Dr. Reinhardt came up and talked about FWC access through part of PalMar, and that conversation was quick. I just wanted to make sure that the board understands Gate 7N comes in through PalMar, Hungryland's public access, and there's a gate, a yellow gate, South Florida Water Management Gate, run by FWC at Gate 7N. It used to be landowner access, it now isn't. Once you cross over that property, or over that gate, there's a South Florida Water Management owned property. Beyond that, there are privately owned properties. I want to make sure that PalMar isn't giving FWC authorization to use PalMar's easement over those properties for access, because PalMar doesn't have that authority. There was a lot of talk about invasives, but there wasn't any talk about access and trespassing and easements, which it can get complicated, but it's a real issue. I'm one of those landowners, and I do not expect FWC to be on my property because they need to get somewhere to take care of invasives without my permission. And PalMar doesn't have the ability to give them that permission. I want to make sure that this board understands that because I don't think they did. Number two, as far as the grading of the roads, the last time that I did some grading off Pratt Whitney Road, after my conversation with Bob, I was stopped by FWC. An FWC officer came out with his hand on his weapon and threatened me to stop work. So if anybody here can speak with FWC about grading for the safety of our contractors and let them know that, PalMar does have the ability to grade, there's some confusion among FWC officers. Some power has gone to their heads. Finally, regarding the pine trees and the beetle, yes, Bob, the damage has been done to the pine trees, but the water's still there. And that's the issue. I don't want to lose sight of that. Bob, you said before that, yep, the dead pine trees is the evidence of what's happening, but the water hasn't gone anywhere. So I think that this board, working with DOT, is appropriate and long overdue. Thank you.
Sure.
Thank you.
Yeah, first off, I don't believe PalMar Water Control District gave permission to South Florida at all. We received a notice from what they were planning on doing in terms of a burn on property that they own. I think the easement issue is going to come to the forefront more and more here in the very near future. It is a somewhat complicated issue, but in other ways, it's pretty simple. PalMar enjoys an easement, and those easements occur over other people's properties. So the underlying land to virtually all of the easements belongs to somebody. It either belongs to a person, corporation, or government. And I think there's going to have to be some discussions about who gets to use and who doesn't get to use that and the methods for obtaining the right to do that. So it's a complicated issue, and I think that more and more, as we've already seen, now that a very significant portion of those properties that were in private ownership by people who, for the most part, didn't even live in Florida. Now that there's hundreds of property owners out there that live here, want to use that property, have certain rights to use that property. I think the role and the influence of PalMar is going to change significantly. And this has been my opinion now for, over 10 or 12 years. I mean, anybody who still has even the dream, if you call it that, that there's going to be some massive, acquisition of this property for government conservation preservation, that door closed, that window closed a long time ago. And, the prospects now are that, we could easily end up with 5,000 individual property owners out there in this area trying to utilize their property. And, and the role of this district, which first, foremost, and only is drainage, is going to become, more important. So I'm making this statement only kind of as a precursor to, some of these future meetings, the fact that, we will be properly funded. We have the ability to address a lot of these things. And the easement issue is a big issue. And so I think that you're going to see a lot more activity on behalf of private property owners looking to enforce their rights to utilize this property. So it's kind of a precautionary note as well. But the same rights, obligations, restrictions all apply to the government-owned land as they do to the privately owned land. So, these things are going to need to be addressed. So, as far as I'm concerned, PalMar did not give permission.
We need to put that in the minutes then, that we did not, it was a request by FWC that we didn't respond to, I would say.
Well, no, it was just a
More notified.
notice. It was just an information. We received the information, I get it.
No,
But I think if there's landowners that want to challenge that access or that route, they're entitled to do that.
Okay, so it's understood that PalMar's read Dr. Reinhardt's letter, but we did not concede or give permission or agree to, correct?
Received it as information.
Okey-doke.
Do we have any other landowners that want to speak? If not, we're going to go to comments from the public for items not on the agenda. Linda, did you sign in? I did. Thank you.
Linda Smith, Jupiter, Florida, Palm Beach County. I want to congratulate you all on your election today, board members. It sounds like you've got some interesting challenges coming up. I encourage you to continue protection and stewardship of this land. Palomar is a special and fragile land, and as indicated by the decline of the pine trees due to the beetle, there are other species besides the pine trees that are going to be impacted in the future. I could list some of those things such as illegal hunting, and actually degradation of the topsoil layer by using too many different types of vehicles. So I continue to ask you to push FDOT regarding the drainage. I think that's a valid issue, but you also need to try to protect the special and fragile nature of this land. Thank you.
Thank you. All righty, anyone else?
I did sign up.
Thank you.
What was the name?
Gail Ladd.
Gail?
Gail, Gail. My name is Gail Ladd. I'm from Jupiter, Florida, and I have concerns, and I'm not sure if you're actually the board to be talking to, but I will also go to Martin County if I need to. But I have concerned after hearing from some residents of Trailside bordering Palomar that there are ATVs, other vehicles racing through Palomar, damaging the environment, which is so fragile, as Linda has mentioned, harassing residents, scaring horses, endangering riders and homeowners, and illegal hunting. I ask all agencies involved for a continued and perhaps more enforcement of existing laws for the Palomar acreage. No one should be afraid or receive threats for speaking out about safety on their own property anywhere, but especially for this concern in particular. Thank you.
Thank you, Gail. All righty, we're at board member comments. Do we have any?
Of course.
Make it brief. I have actually a 1 o'clock agenda review. Go ahead.
This is actually addressed to Mary. I just want to ask, I guess, maybe state. So if there are landowners who continue to object with, possibly disagree with the action that was taken at the annual landowners meeting regarding the election, that the recourse for those landowners would be a civil suit and circuit court, and the purpose would be to either, the result of that action would result in either the court agreeing with the action taken by Palomar or disagreeing, and part of the disagreement could be the reversal or overturning of the results of that election, and in fact, even potentially removing the board member that was seated today. So again, for the record, and I say right up front, I'm not one of those, but if there were a landowner that wanted to make that challenge, that would be the proper mechanism to do that.
That's
That's the venue, and virtually all of the items that you had expressed in your report that were outside the jurisdiction of your office or for Palomar to analyze primarily it's a validation of the proxies. That was the big deal. That those could, hopefully would, be answered in a court and could still affect the results of this annual meeting.
That's possible.
Yeah, okay, all
I
right.
think we tried to make that clear. There are certain areas that were outside the purview of the district in these particular issues, and there are legal issues that if an entity, or if an individual wanted to challenge or have a question, that would be the vehicle that they would have to utilize.
And since this was happened at the annual meeting of landowners, who would be the defendant?
I'm not, I believe it's the district. It's probably the district.
So the district would have to choose to defend,
Yes.
that lawsuit or not, and would incur the cost,
That's
I
a
guess, if
possibility.
that's doing that.
Depends on the outcome.
And the outcome, yeah. Oh, and that's something that could be litigated as well.
What?
The plaintiff in this case could ask for costs?
They can ask for costs. Certainly can always ask for costs.
Okay, all right, I'm just trying to understand where we are.
Yes,
Okay,
sir.
thank you.
Thank you. Any other comments?
Yeah, one more question, please. Are we due for a 5-year review of our water control plan?
It's called a public facilities report, and technically, you're supposed to do it every 5 years. If you do a water control plan amendment, that's considered compliance with your public facilities report, but that is something that is possible. We can double check, but it usually is a 5-year, it's a 5-year time period. There are certain little exceptions when you've gone through the plan process and whatever.
So we'll take a look at that.
Yes, sir.
Thank you.
Thank you. Anyone else? Well, it is 12, I don't even know,
37.
12:37. Thank you all for being here today. The meeting is adjourned. And I have a 1 o'clock agenda review that I'm going to.
Oh.